We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
In Spouses Minjola versus Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised
is with respect to estate, alright? Gifts, alright? Bequest, devices. If you try to analyze it, these are actually the transfer taxes being pertained to in the National Internal Revenue Code. They are the estate for inheritance or succession, and then the donor's tax for gifts, right? So one is mortis causa, that's the estate tax, and the other one is inter vivos. Now, incidentally, I just got reminded that, well, you learned in the general principles of taxation that the main purpose of taxation is actually to raise revenue. But in the case of donor's tax, it's not actually the main purpose, although it's still one of the purposes of donor's tax. But primarily, donor's tax is actually, alright,
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Rule 30 is trial in civil cases, while Rule 119 is trial in criminal cases. Under Rule 119, trial in criminal cases, I give emphasis to the following issues. The first is the continuous trial, which I've already partly discussed with you. Just refer yourselves to the continuous trial rule in criminal cases, the latest on the issue. Then the second issue that I would like to discuss in Rule 119 would be the mode of discovery, which should be discussed in relation to Rule 23 of
answer either way, class, and so long as you're able to present in your answer basic precepts, sound ones and rational ones, then it should be your answer given full credit. It would all depend on, as I always announce in my classes, it would always depend on your English. All right. You say that the successor president can act on those bills. Why? Well, because the Constitution does not make any distinction as to the rule of presentment and the competence of either predecessor or successor president to approve or veto the same. The only prescription in the Constitution is that if it were not acted within 30 days, then it shall be considered essentially as having lapsed into law. But you can answer that way, class, and that should be a correct answer. But then you can answer the other way.
Importante, again, sequential, you may skip, but make sure that you are still on that track. And what best way for you to make sure that you are still on track is, again, to devote a page to a main question. make sure that you do this so that you wouldn't be forced to resort to putting notes like how you do it in law school, because in the bar examinations no more. Di ba yung notes mo dun sa examiner, Mr. Bar Examiner, please check the last page of my booklet because that's where I put my answer to this question. That's not allowed anymore because that's an unnecessary marking, right? So, kung sa law school, nagagawa yun dati, puro arrows, you try to direct your professor on where to do.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the person.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
He may be held liable for staffa by misappropriation or conversion. Okay, staffa by misappropriation or conversion. Why can't that not be theft? Why can't that not be carnapping, which is of similar nature of theft? Okay, it is because Mr. A's possession over that car is not only physical or material, it is juridical as well. For the next 7 days from the time he rented the car, okay, he not only has physical possession of that car, he has juridical possession of that car as well. Why did I say that?
The other source of labor principles is the Constitution. Do not enter the gates of USC unless you have mastered the four corners of Section 3, Article 13 of the Constitution of 1987. How important is this provision? Based on this constitutional provision, there were questions given in 1988, 96, 98. 2007, 2008, 2009, 2011, 2012. So if you this constitutional provision figured in those barriers, then it means that it is an area that requires mastery. The first question in 1998 was this: what are the salient features of the protection?
In the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
Unang pumaparte sa mana, BIR, kasi mayroon tinatag na estate tax. Okay? Maganda ngayon, isa na lamang ang rate, 6% per 6% na lang ng net estate. Okay? Unlike before, the computation of the estate tax was a little complicated, and long before, meron ng estate tax, meron pang inheritance tax na mas magulong po i-compute. Kaya lang, fortunately, ito panahon ni Presidente Duterte, legislature passed a law simplifying the computation of estate taxes. A flat rate of 6% of the net estate. Hindi na graduated.
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section hashtag VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is the founding and managing partner of Cruz Altares and Associates Law Office based in city of Mikawayan. Presently, he is the college dean and vice chairman of the board of directors of Mikawayan College. His being the city administrator and formerly senior consultant to the city mayor of the city of Valenzuela, Metro Manila. A certified public accountant. He has also co-authored 11 books on various commercial law subjects and criminology law subjects, all published by Central Books. Without further ado, let us all welcome Dean Rtiseo Rubio Cruz.
Good day, everyone. I am Attorney Toots Cruz, and welcome to the free online lecture brought to you by the virtual law companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity, like the VLC Facebook page, or subscribe to VLC YouTube channel and share this live session. Host a watch party and tag your friends now, and together learn at the comfort of your homes. Before we start, please comment VLC if you can hear me clearly. Okay. So we start now with our discussion for this afternoon. My topic for this afternoon is partnership law. I will be using the 2020 Philippine Bar Exams syllabus for commercial law. Prior to the 2020 syllabus prepared by the bar chairman's office, partnership is categorized or included in the civil law part of your Philippine Bar Exams. But in the 2020 and 2021 Philippine Bar Examination, Chairman Leonen included it in the business organization part of the commercial law. So we will be using this particular syllabus as a guide in our discussion for this afternoon. Okay. What is the operative law? It is important that we know what the operative law for any particular law is, no? In order for us to be able to apply the correct law. The operative law as far as partnership law is concerned is the new civil code, most particularly Book 4 under obligations and contracts and Title 9 partnership,
Law Center.
Articles 1767 to 1867. Let's try to define what a contract of partnership is. Article 1767 states that by a contract of partnership, two or more persons binds themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Two or more persons may also form a partnership for the exercise of a profession. Let me note that when you are asked to define or you find a question in the bar exams which asks for a definition of what a partnership is or what a contract of partnership is, it is my tip to you to give the complete answer, both paragraph 1 and paragraph 2, in order to get a complete credit for your answers. What are the characteristics of a contract of partnership? A contract of partnership is nominate. It has a special name and designation in our laws. It is consensual. It is perfected by mere consent. That is upon the expressed or implied agreement between two or more persons. In certain cases, as so provided by law, there are certain formalities also required. It is bilateral or multilateral. It is entered into by two or more persons, and the rights and obligations arising therefrom are always reciprocal. It is onerous. Each party aspires to procure for himself a benefit through the giving of something. Certain contributions to have to be made by all the parties concerned. It is commutative. The undertaking of each of the partners is considered as the equivalent of that of the others. It is a principal contract. It does not depend for its existence or validity upon some other contract. It is preparatory, entered into as a means to an end in the sense that after it has been entered into, other contracts essential in the carrying out of its purpose can also be entered into. What are the essential requisites of a contract of partnership? One, a valid contract. A contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. That is Article 1305 of the New Civil Code. What are the essential elements without which a contract cannot exist? The mnemonics is COC. One is consent of the contracting parties. Second, object certain, which is the subject matter of the contract. And third is the cause of the obligation, which is established. That is 1318 of the New Civil Code. Second, legal capacity of the parties. Natural persons, no problem there, because any person who can enter into a simple contract may also form a contract of partnership. The juridical persons, no? Juridical persons like partnerships and corporations. As far as partnerships are concerned, the answer is yes. Another partnership can be a partner in a partnership, in another partnership. There is no prohibition. If you remember the definition under 1767, it says that two or more persons. So that could also refer, the other persons there could also refer to another partnership. However, as far as corporations are concerned, being a juridical person also, a corporation under the old code, which is the Corporation Code of the Philippines or Batas Pambansa Bilang 68, the answer is no. Under that particular law, a corporation may not be a partner or may not form a partnership. However, in the advent of the revised Corporation Code or Republic Act 11232, which took effect in February 23, 2019, there is now a statutory provision or explicit provision allowing a corporation to enter into a partnership. What is my legal basis? My legal basis is Section 35 of the RCC, which states that corporate powers and capacity, every corporation incorporated under this code has the power and capacity under paragraph H to enter into a partnership, joint venture, merger, consolidation, or any other commercial agreement with natural and juridical persons. So with that particular provision under the revised corporation code, a partnership, no, between a corporation and another partnership may now be entered into legally. Third, there must be a mutual contribution of money, property, or industry to a common fund. Economic or commercial goodwill may be contributed, but no political goodwill or political influence, as this is contrary to good customs. Industry contributed may also be intellectual or physical. Later on in our discussion of a limited partner, we will see that a limited partner cannot contribute merely industry or services to the partnership. That is Article 1845. The fourth requisite would be in objects or subject matter must be lawful. And the fifth one is that the primary purpose must be to obtain profits and to divide the same among the partners. The object must be for profit
Villasis
and
Law
not
Center.
merely for common enjoyment. Otherwise, only a co-ownership
Villasis Law
has been
Center.
formed. Pecuniary profit did not be the only aim. It is enough that it is the principal purpose, even if there are incidentally moral, social, or spiritual ends. Let's try to distinguish between a partnership and a joint venture. When two or more entities come together to an understanding for a specific action or purpose, then it is known as a joint venture. And when the purpose is completed, the said joint venture shall come to an end, as it is temporary in nature. Whereas a partnership is an understanding among its partners for a common goal and has a separate status which is more permanent in nature. A joint venture has no distinct juridical personality, unlike a partnership. A joint venture is defined as a type of business organization wherein two or more firms come together for a specific purpose to attain a certain activity or task and complete a specific project. The venture formed is non-permanent or temporary in nature. As I've said, the partnership has a separate juridical personality, and this is embodied in Article 1768. No? What does 1768 tell us? The partnership has a juridical personality separate and distinct from that of each of the partners, even in the case of failure to comply with the requirements under Article 1772, first paragraph. What is that particular provision under the first paragraph of 1772? It is every contract of partnership having a capital of 3,000 pesos or more. Let me stress that. A capital of 3,000 pesos or more. No? So the threshold is 3,000 or greater than 3,000. That is different from less than 3,000. No? Okay? So a capital of 3,000 pesos or more. So the moment that it becomes 3,000 or more, even a cent more, then it has to comply with 1772 first paragraph. Every contract of partnership having a capital of 3,000 pesos or more in money, property, shall appear in a public instrument, which must be recorded in the Office of the Securities and Exchange Commission. Question, okay? In Cruz, Altares, and Associates Law Offices, with attorneys Cruz and Altares are partners, how many persons are there? I hope that you are enjoying this webinar. If so, please comment VLC. So back to our question. What is the answer? And the answer is, there are three persons. Two natural persons, that is attorneys Cruz and Altares, and one juridical person, which is the firm. This is in consonance with the principle that a partnership has a separate and distinct juridical personality. Article 1769 lays down certain rules in determining the existence of a contract of partnership, the purpose of which is to indicate some test to determine if what may seem to be a partnership really is one or it is not. No? This is the main question, no, that you have to answer in answering questions in the Philippine bar exams in relation to a partnership. Because if there is no partnership, then the law on partnership that we are discussing now would not be applicable. What would be applicable would be maybe other provisions of the civil code under obligations and contracts, but not partnership law. Okay? So what are these rules laid down in 1769? One, except as provided by Article 1825, which is partnership by estoppel, persons who are not partners as to each other are also not partners to third person. Second, co-ownership or co-possession does not by itself establish a partnership, whether such co-ownership or co-possessors do or do not share any profits made by the use of the property. Third, sharing of gross returns does not by itself establish a partnership, whether or not the persons sharing them have a joint or common right or interest in any property from which the returns are derived. And the fourth test would be the receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business. But no such inference shall be drawn if such profits were received in payment of A, a debt by installment or otherwise, B, as wages of an employee or rent to landlord, or C, as an annuity to a widow or representative of a deceased partner. And D, as interest on a loan, though the payment of amount varies with the profits of the business. And lastly, as a consideration for sale of a goodwill being the reputation for good name of an establishment, a reputation for competence, honesty, and fair dealings, but its value is in attracting customers and not in securing credit of a business
Villasis
or
Law
other
Center.
property by installment or otherwise. There is no
Villasis Law
definite
Center.
criterion that can be set up except that all characteristics of the contract of partnership must be present. It would therefore be a question of fact. What are the object of a partnership? The object of the partnership must be lawful. That is, it must be within the commerce of man. It is possible. It is not contrary to law, good morals, good customs, public order, and public policy. What would be the legal consequence if the object is unlawful? The contract of partnership is void ab initio, or void from the very beginning. That is Article 1770. Note, if the partnership has several purposes and only one or several are illegal, the partnership can still validly exist so long as the illegal purpose can be separated from the legal purpose or purposes. Is a judicial decree needed to dissolve an unlawful partnership? No, for the contract is void from the very beginning, therefore, never has it existed from the point of view of the law. How about the form? Let's go into the form of partnership. There is a general rule. The general rule is that a partnership may be valid and enforceable and may be constituted in any form. Being a general rule, it is also subject to certain exceptions. Exceptions are: one, where immovables or real rights are contributed, it must be in a public instrument. There must be an inventory duly signed by the partners and attached to the public instrument. Otherwise, the partnership is void. That is Article 1771 and 1773. Second exception, if the capital is 3,000 pesos or more, it must appear in a public instrument and registered with the Office of the Securities and Exchange Commission. Failure to comply does not affect the liability of partnerships and partners to third persons. Under 1776, please be mindful that as to its object, a partnership is either universal or particular. As regards the liability of the partners, a partnership may be general or limited. Under 1777, it states that a universal partnership may refer to all the present property or to all the profits. In my long years of practice, I have not seen yet a universal partnership as to present property or as to all the profits. No? But then it is in our statutes, and maybe we still have to know what a universal partnership of all present property or a universal partnership of all profits are. A particular partnership has for its object, no? One, determinate things, their use or fruits or specific undertaking, or the exercise of a profession or a vocation. That is Article 1783. This is more or less the kind of partnership that we are familiar with. And this is also the partnership that you, being a future lawyers, no, would be forming in the exercise of your profession or your vocation as lawyers. A partnership begins from the moment of the execution of the contract, unless it is otherwise stated. That is Article 1784. Being a consensual contract, it exists upon the moment of the celebration of the contract by the parties. Its registration with the SEC is not essential to give it a juridical personality. Life and birth of a partnership is predicated on the mutual desire and consent of the party. No time limit for the existence of partnership. It exists, and partners are bound by such relationship until an event occurs that will cause its dissolution. We will be discussing the causes of dissolution and the winding up and the termination in the latter part of our discussions. The statutes of fraud, which is Article 1403, more particularly the second paragraph, letter A, requires that all agreements which are to be fulfilled within 1 year, sorry, that's 1 year, not 10 years, must be in writing. Future partnership is possible to be formed if the partner so provided a commencement date for its activity is so provided. There is a concept of a partnership at will in our statutes, no? That is Article 1785. When a partnership for a fixed term or a particular undertaking is continued after the termination of such term or particular undertaking without an express agreement, the rights and obligations and duties of the partners remain the same as they were at such termination, so far as it is consistent with a partnership at will. A continuation of a business by the partners or such of them as habitually acted therein during the term without any settlement or liquidation of a partnership affairs is prima facie evidence
Villasis
of
Law
a
Center.
continuation of the partnership. It is called a partnership at
Villasis Law
will
Center.
because its continued existence really depend upon the will of the partners or even the will of any of them. It is a partnership at will only and only if there was already an existing partnership prior to the extension by the will of the partners because either the term of the original partnership or the purpose or the goal of which that particular partnership already existing has already been attained and therefore that partnership is deemed already dissolved. It is called a partnership at will because in that particular instance, the partners have consented to carrying on or continuing the partnership. What are the different duties of every partner? There are three under Article 1786. And what are those? One, the duty to contribute what had been promised. Second, the duty to deliver the fruits of what should have been delivered. And third is the duty to warrant. The warranty in case of eviction refers to specific and determinate things already contributed to the partnership. There is eviction whenever by final judgment based on a right prior to the sale or an act imputable to the partnership is deprived of the whole or a part of the thing purchased. What are the obligations of the partners with respect to their contributions, which is the first of the important duty of a partner? One, they are to contribute as promised. Second, to answer for eviction in case the partnership is deprived of the determinate property contributed. Third, to answer for the fruits of which he delayed in delivery without need of any demand. And fourth, to preserve the thing with the diligence of a good father of a family pending delivery. And lastly, to immediately indemnify the partnership for any damage caused to it by the retention of the same or by the delay of its contribution. What would be the legal effect for failure to contribute what has been promised? Ipso facto, he becomes a debtor of the partnership. No? Remember, in our obligations and contracts, we have learned that in order for a party to be in default or in mora, a demand is needed or a formal demand is needed. However, in the case of a partner who failed to contribute what he has promised to the partnership, no such demand is needed, no, because time is of the essence in terms of the contribution of what has been promised to the partnership. Therefore, ipso facto, the partner becomes a debtor of the partnership. What is the remedy? The remedy for failure to contribute is not rescission, but an action for specific performance. Let's go to the different kinds of partners. I hope that you are still okay, no? I hope that you are learning from this webinar. Share your takeaways so far by typing them in the comment section. Okay, let's go ahead and discuss the different kinds of partners. Well, what are the different kinds of partners under the law? One, you have the capitalist partner. He is one who furnishes capital. You have the industrial partner, one who furnishes industry or labor. You have the capitalist and industrial partner. So pwede pala yun na both capitalist and industrial partner ang iisang partner. Yes, it is allowed, no? So he is one who contributes both capital and industry to the partnership. In terms of liability, no, you can have a general partner. He is one who is liable beyond the extent of his contribution. And second, and in addition to that, you will have a limited partner. He is one who is liable only to the extent of his capital contribution. A managing partner is one who manages actively the firm's affairs. A silent partner is one who does not participate in the management, though he shares in the profits and losses of the partnership. A liquidating partner is one who liquidates or winds up the affairs of the partnership after it has been dissolved. An ostensible partner is one whose connection with the partnership is both public and open. How about a secret partner? A secret partner is one whose connection with the firm is concealed or kept secret. A dormant partner is one who is both secret and silent partner. And lastly, you have your nominal partner. He is one who is not really a partner and who becomes liable as such insofar as third persons are concerned because he allowed his name to be used by the partnership. An example of this would be a partner by Estotel. Why did we discuss the different kinds of partners? Because if you try to review some of the questions in the bar exams relative to partnership, there have been several years that a question has been asked asking for a definition of the different kinds of partners. We discussed the capitalist and industrial partner. No, let's try to distinguish one from the other. As to contribution, a capitalist partner, as we said, contributes either money or property or property. An industrial partner contributes only his
Villasis
industry.
Law Center.
It could either be mental or physical. As to engagement in other
Villasis
businesses,
Law
as so
Center.
provided in certain articles under the partnership law, a capitalist partner cannot generally engage in the same or similar enterprise as that is of his firm, or of his partnership. The test would be the possibility of unfair competition, but that is the general rule. Because if he has been allowed by his other partners to engage in other similar businesses or in other businesses, that is allowed. That is within the realm of the freedom to contract. Because so long as it is not against the law, public order, public policy, good customs, or good morals. No? As far as industrial partners are concerned, they cannot engage in any business for himself. But again, that is the general rule, because if he would be allowed by his partners and by stipulation or agreement that he would be allowed to engage in any business for himself, even if he is an industrial partner, then that is also allowed. As to profit sharings, capitalist partner shares according to their agreement, and if none, it is pro rata to his capital contributions. How about an industrial partner? Industrial partner would receive a share which is just and equitable. As to losses, capitalist partners as to the agreement. In the absence of the agreement as to losses, then the agreement as to the profits, if none, pro rata as to the capital contributions. How about industrial partners? Industrial partners are exempt as to sharing in the losses between partners, but they are liable to strangers without prejudice to reimbursements from the capitalist partners. We will be discussing more of that in the latter part of this discussion. Each partner is an agent of the partnership. This is basically the foundation of a partnership, no? And each partner is an agent of the partnership. That is the general rule. What is the exception? The exception is so provided that as otherwise stipulated or agreed upon by the partners in the partnership. That is Article 1796. We've been talking about sharing of profits and losses. Let's try to discuss the rules, no, as far as profits and losses sharings are concerned under the Civil Code. The general rule is that profits and losses are to be distributed amongst the partners based on their agreement or stipulation. Exception, if it is silent, it is to be distributed as follows. As to profits, if capitalist partner, it would be based on their capital contribution. If an industrial partner, what is just and equitable has the first preference over capitalist partners in the distribution of the profits. And third, if both an industrial and capitalist partner it would be based both on his capital contribution and what is just and equitable as far as his industrial partnership in the partnership is concerned. As to losses, if capital is partner, it is based on capital contribution. If an industrial partner, he does not share in the losses, but shares in the liabilities. That is a statutory provision under Article 1860. General rule again, no stipulation can be had excluding any partner from the sharing of profits or losses. Otherwise, such agreement or stipulation is void. That is explicit in Article 1799. Exception, as the law categorically and specifically allows or mandates an industrial partner is not to share in the losses to be incurred by the partnership. So that is the only exception wherein there is an agreement or stipulation that a partner in a partnership would not share in the losses. Otherwise, that particular agreement or stipulation entered into between the partners is considered void as it is against public policy. Rules on managing partners. As we said earlier, a managing partner is one who manages the day-to-day activities of the partnership. General rule, a managing partner can do all acts of administration in spite of any opposition from the other partners, and if so appointed in the articles of co-partnership. Exception, the managing partner so named and appointed in the articles of co-partnership is in bad faith. Because in the appointment of a managing partner, there are two ways to appoint a managing partner. One is that he is already named in the articles of co-partnership. And if not named in the articles of co-partnership, he has been elected or appointed amongst the partners in a meeting of the partners with that particular agenda in mind, which is the appointment of a managing partner. Once again, as a general rule, a managing partner appointed in the articles of co-partnership cannot be removed. No? Why? Because he has been named in the articles of co-partnership. Except the managing partner can be removed with just and lawful cause. The
Villasis
vote
Law
of the
Center.
controlling partner is needed to effect such change.
Villasis Law Center.
As you very well know already, when you are trying to study the law or preparing for the bar exams, it is important to know the general rule, but more so, it is more important to know the exception, and in certain cases, the exception to the exception. Most likely, the questions would not be revolving upon the general rule because that is assumed by the examiners that you already know the general rule. The questions might revolve on the exception and the exception to the exceptions. What are acts of administration? Acts of administrations are the day-to-day activities of the partnership. It is routinary in character. Contradistinguished to acts of strict dominion or acts of ownership. These are disposal or acts of ownership which include selling, encumbering, mortgaging, leasing, or of properties of the partnership. That is Article 1800. A partner may associate any person with him in his share in the partnership. Such associate, however, will not be a partner unless with the consent of the other partners. Do you still remember what that particular principle in partnership law is? A little later we'll discuss. The rule applies even if the partner took an associate is the managing partner of the partnership. This is an application of the doctrine of, yes, you correctly remembered the doctrine. That is the doctrine of delictus personae or the doctrine of delictus persona. What is this? It's Latin and its loose translation is choice of the person. By this term, it is understood that the right of partners to exercise their choice and preference as to the admission of any new members to the partnership and as to the persons to be admitted, if any, is applied to show that partners have the right to select their co-partners and that no set of partners can take another person into the partnership without the consent of each of the partners. That is your doctrine of delictus persona, and it is embodied in Article 1804. Let's go to the different property rights of a partner. The different property rights of the partner as stated in the Civil Code are: one, his rights in specific partnership property. A and B contributed each a car for the partnership. The two cars are specific partnership properties. These are not assignable. These are not subject to support, and they are being co-owners with the other partners of the specific partnership property. His second property right is what we call his interest in the partnership. The partner's share of the profits and losses are the partner's interest in the partnership. This is without mentioning any particular or specific property of the partnership. This is fully assignable, and it is also subject to support. The most important right of a partner is the third property right, and that is his right to participate in the management of the partnership. Why is this an important right of the partner? Because his participation in the management would redound to the benefit, no, of the partnership in order for it to attain its goal of making profits and the profits to be divided between the partners. That is Article 1810. What is the difference between liabilities and losses? Why is this important? Because of two articles, no, that we'll be discussing, no, and these particular articles, no, is usually the trick question in the Philippine bar exams, because some of the examinees, no, interchange liabilities and losses, and therefore they commit the mistake of applying which particular article or which particular provision of the law to apply. No, okay. So let's try to distinguish liabilities from losses. No? All partners, regardless of whether a capitalist or industrial partner, are liable to third parties for partnership obligations and debts. They are liable pro rata. The relationship is secondary, meaning that after exhausting all partnership assets jointly and equally, that is the only time that they are supposed to be liable for partnership liability. Pro rata, in the context of partnership law, in the context of this particular article, is meant to be equal in terms of number of partners or proportionate in the number of partners and not in relation to their capital contribution. The partners may be named party defendants to partnership obligation in the same action, but subject to a prior exhaustion of partnership properties. The partners are effectively guarantors of the partnership liabilities. Industrial partners are liable for partnership liabilities, even though they are not liable for losses, but subject from recovery from other partners unless the contrary is stipulated between the partners.
Villasis Law Center.
This is the two articles that I was referring to, and that is Article 1816 and Article 1797, which at first glance may look like they are not compatible, but in truth and in fact, they are complementary. No? The provision that industrial partners are exempt from losses, as stated in 1797, no, relates to liabilities among partners and not amongst third parties, meaning that if there is an agreement between the parties or the partners in the particular partnership, that is practically legal, no? But it would not bind third parties. So if an industrial partner, no, may not raise the defense that there is an agreement between the partners that that he or she is not liable for partnership liability, because under the statutory provision under Article 1816, even industrial partners are liable for partnership liabilities. Any stipulation regarding the pro rata and subsidiary liabilities of the partners as laid down in Article 1816 is void. This is not absolute because as we have stated, it is only void among third parties, not, no, but remains, sorry, typo error, but remains valid as between the partners. That is Article 1817. General rule: a person is not bound by the act, admission, or statement or agreement of another of which he has no knowledge or which he has not given his consent, except by virtue of a particular relations between them. What is the exception? Unless he is acting within the authority and written the scope of his expenses, implied or his apparent authority. General rule: notice or knowledge of any partner of any matter relating to the partnership affairs serves as notice and knowledge to the partnership. Exception: in case of fraud on the partnership committed by or with the consent of the partner. That is Article 1821. If you would remember the syllabus that was released by the Office of the Chairman of the Bar exams for 2020-2021, all of the things that we are discussing today, no, are embodied in that particular syllabus or guidelines because we use that particular guidelines in drafting or in preparing for this session. Let's try to remember what solidarity liability and how is it applicable in partnership law. No? Before we do that, are you still okay? Are you still enjoying this webinar? If so, please type VLC in the comment portion. Okay, let's continue. Solidarity liability of partners to third persons and to partnership to persons for: 1, wrongful act or omission, or 2nd, breach of trust by a partner acting within the scope of his authority, regardless if ratified or assented to by such partner. The rules of respondent superior, if you remember under your torts and damages, or vicarious liability rule under Article 2180 shall also be applicable. No? This is Articles 1822, 1823, and 1824 of the Civil Code. Earlier, we discussed partnership by estoppel. Let's try to refresh our minds of what estoppel is. Estoppel is a bar which precludes a person from denying or asserting contrary to that which has been established as the truth by his own deeds or representations, either expressed or implied. Rules as far as partnership by estoppel are concerned. 1, if all the partners consented and there is an existing partnership, then the act is a partnership act. 2nd, if there is no existing partnership and all consented or not all partners of an existing partnership consented, then the liability is joint and pro rata. If, on the other hand, no partnership exists and not all the partners consented, then separate liability or not one or none of the partners consented in the existing partnership, liability is separate. Estoppel does not create a partnership as between alleged partners, only considered as such as to third persons by reason of equitable principle of estoppel. That is Article 1825. A partner admitted into an existing partnership is liable for partnership obligations arising before his admission as though he has been a partner when such obligation were incurred. Exception: when there has been a stipulation to the contrary. What is the rationale behind this particular principle? It is because he is already joining a stable partnership. That is Article 1826. Let's go to the preference of credit. No? In the settlement during dissolution, winding up and termination of the partnership, the preference of credit is stated under
Villasis
the
Law
Civil
Center.
Code. No? First, third-party creditors. No? Either
Villasis Law
secured
Center.
or unsecured. Second, Partners who are also creditors of the partnership with respect to partnership assets. Why? Because partners are not prohibited from lending money to the partnership when there is a need for certain funds, no, to be advanced by the partners in the form of credit to the partnership. So in terms of preference of credit, it is only second to third party creditors. Okay, we're almost in the end of the life of a partnership. We are now in the dissolution and winding up stage. No? Okay. Dissolution. Dissolution of a partnership refers to the change in the relations between the partners in a partnership caused by any partner ceasing to be associated in the carrying of the business. It is different from winding up because winding up is the process of settling partnership affairs or businesses after the dissolution. For corporation, under the revised corporation code, it is 3 years in the maximum. But for partnership, there is no definite period provided by law. Therefore, it is indefinite. Termination under Article 1828. Termination is that point in time that when all partners' affairs are completely wound up and finally settled. This signifies the end of the partnership. On dissolution of a partnership, the partnership is not terminated upon the winding up of the partner's affairs until the winding up of the partnership affairs are completed. Dissolution does not automatically result in the termination of the legal personality of the partnership, not related to the partners. No new business, however, can be undertaken during this period. Only a continuation of already started business. That is Article 1829. Let's go to the different causes of dissolution. No? The causes of dissolution of a partnership may either be by will of the partners or by operation of the law. The list under Article 1830 is an exclusive list. What do we mean by exclusive list? It's either here or it's not a cause for the dissolution of the partnership. And what are these? Termination of the definite terms of or undertaking. In case of partnership at will, as we have discussed earlier, no definite term is fixed or undertaking at express will of a partner who acted in good faith, by express will of any partner who acted in good faith, and by express will of all the partners. Please remember that insolvency of any partner or of the partnership is also a cause for dissolution. If there is a contravention of the agreement, either expressly or impliedly by the parties, this could also be a cause for dissolution because the partnership is a mutual contract. So partners have the power, not necessarily the right, to dissolve the partnership. Civil interdiction is another cause for dissolution. Termination or loss of the thing contributed, unlawful to carry out the business of the firm, a court order under Article 1831, and the death of any partner. Again, let me point out, the list is exclusive. There is no other cause of dissolution except those instances so provided in this particular article. This is Article 1830. Dissolution does not by itself discharge the liability of any partner. Even a deceased partner is still liable for liabilities or obligation of the partnership incurred while he is a partner. So third-party creditors may run after the estate of the deceased partner, but preference is given to the deceased partner's personal creditors. That is under Article 1835. Who may wind up the affairs of the partnership? The partner who did not wrongfully dissolve the partnership, or the legal representative of the last surviving partner who is not insolvent, has the right to wind up the partnership affairs. This is Article 1836. Liquidation. Liquidation means converting assets to cash, no, of the partnership. And this should be as stipulated or in the absence of such stipulation by the pertinent provision of the new civil code. That is Article 1837. I hope that you're still enjoying the webinar. If you are, please comment VLC in the comment box. Okay, I'm into the final part, no? Okay, we go to limited partnership. What is a limited partnership under Article 1843? A limited partnership is one formed by two or more persons under the provisions of the new civil code, having as members one or more general partners and one or more limited partners. The limited partners as such shall not be bound with the obligations of the partnership. That is Article 1843. Limited partners shall not be personally liable for the partnership debts. General rule. All partners are personally liable,
Villasis Law
including
Center.
industrial partners. We saw that already. Pro rata per head or in
Villasis
equal
Law Center.
shares for partnership obligations, except limited partners who are like stockholders of a corporation. They are only liable to the extent of their capital contributions. Limited partnership, absence any statutory prohibition, may carry any business, could be carried on by a general partnership. In summary, the following are the features of a limited partnership. Liability of limited partner is only up to his capital contribution, nor right to participate in management. Limited partner to contribute only money or property, but not industry. Limited partner is not a proper party to enforce liability. And the limited partner share is fully assignable. His name generally cannot appear in the firm's name, or if it does, he becomes liable as a general partner. Limited partner has no prohibition to engage in the same line of business unless stipulated. Retirement death of a limited partner does not dissolve the partnership. In summary, contradistinguished from that of a limited partnership, a general partner is personally liable for partnership obligation. All general partners are agents with rights in management. General partners contributes money, property, or industry. General partners are proper parties in any lawsuit. They are not freely assignable, may or may not appear in the firm's name, cannot engage in the same line of business as a general rule, subject to the exceptions. Death, retirement of a general partner dissolves the partnership. Limited partnership is not formed by mere consent. It must have substantial compliance in good faith with the formalities set forth by the law. There is no such thing as an oral limited partnership. It must always be in writing. Two essential requirements for the formation of a limited partnership. One, a certificate of limited partnership which states matters enumerated by law, including, among others, the sharing of profits and compensation of limited partners. And second, must be filed with the SEC. Filing with the SEC is constructive notice to potential creditors or persons dealing with the firm. That is Article 1844. A limited partner cannot contribute industry and services to the partnership. General partner and limited partner at the same time is possible and is legal under our statutes. A limited partner, industrial partner cannot be possible because of the provision on the contribution of industry by an industrial partner, which is not allowed or prohibited. No? That is Article 1845. Let's go to another rule. Name of limited partners must not appear in the firm's name, or else they are liable as general partners to those who extend credit and without knowledge that he or they are simply limited partners of the partnership. What are the exceptions? The exceptions are the name is also the surname of a general partner. So pareho silang Cruz, pareho silang Santos, pareho silang De La Cruz, nung general partner. No? And second, before he became a limited partner, it is already carried under the name wherein his surname appears. So it is possible that prior to his being a limited partner, he was a general partner in that particular partnership. And it was simply, and his share was converted into a limited partner share. No? That is Article 1846. An existing limited partnership may admit additional limited partners, but there is a need to amend the articles of co-partnership. That is Article 1849. Of course, subject to the guidelines or internal implementing rules and regulations provided by the SEC in terms of admitting additional limited partners. No, I would suggest, no, because partnerships are also within the jurisdiction of the SEC. Just like any corporation, I would suggest that if you have the time, you also try to study or keep updated with regard to new issuances by the SEC, no, in implementing the various provisions of the civil code or the special law governing corporations and other special laws of regulatory agencies, no, covering either corporations or partnerships. Continuing on, a limited partner is referred to a mere contributor. He is practically a stranger in the limited partnership whose liability is limited to his interest in the firm without any right and power to participate in the management and control of the business. Since limited partners are not principals in partnership transactions, their liability as a general rule is to the partnership, not to the creditor of the partnership. For the same reason, they have no right to ascertain against third persons against whom the partnership has any enforceable claim. Unless, therefore, a limited partner is also a general partner or has
Villasis Law
become
Center.
liable as a general partner, he is not a proper party to
Villasis Law
proceedings by or against the partnership. Okay, so basically that is the end of our session this afternoon. Thank you very much for watching and for staying until the end of this presentation. Please visit the VLC website at www.villasislawcenter.com to know more about the virtual law companion and prepare for the bar exams at any time, anywhere, and from any mobile device. Together we can. If you have any questions or you want to contact me, these are my contact details. My gratitude to the Villasis Law Center for this opportunity to be with you today. So thank you very much and have a good day, and I wish you luck when you take the bar exams. Thank you and a pleasant day to all.
In Spouses Minjola British Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised
to estate, alright? Gifts, alright? Bequest, devices. If you try to analyze it, these are actually the transfer taxes being pertained to in the National Internal Revenue Code. They are the estate for inheritance or succession, and then the donor's tax for gifts, right? So one is mortis causa, that's the estate tax, and the other one is inter vivos. Now, incidentally, I just got reminded that, well, you learned in the general principles of taxation that the main purpose of taxation is actually to raise revenue. But in the case of donor's tax, it's not actually the main purpose, although it's still one of the purposes of donor's tax. But primarily, donor's tax is actually, alright,
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Rule 30 is trial in civil cases, while Rule 119 is trial in criminal cases. Under Rule 119, trial in criminal cases, I give emphasis to the following issues. The first is the continuous trial, which I've already partly discussed with you. Just refer yourselves to the continuous trial rule in criminal cases, the latest on the issue. Then the second issue that I would like to discuss in Rule 119 would be the mode of discovery, which should be discussed in relation to Rule 23 of
You can answer either way, class, and so long as you're able to present in your answer basic precepts, sound ones and rational ones, then it should be your answer given full credit. It would all depend on, as I always announce in my classes, it would always depend on your English. All right. You say that the successor president can act on those bills. Why? Well, because the Constitution does not make any distinction as to the rule of presentment and the competence of either predecessor or successor president to approve or veto the same. The only prescription in the Constitution is that if it were not acted within 30 days, then it shall be considered essentially as having lapsed into law. But you can answer that way, class, and that should be a correct answer. But then you can answer the other way.
Importante, again, sequential, you may skip, but make sure that you are still on that track. And what best way for you to make sure that you are still on track is, again, to devote a page to a main question. make sure that you do this so that you wouldn't be forced to resort to putting notes like how you do it in law school, because in the bar examinations no more. Di ba yung notes mo dun sa examiner, Mr. Bar Examiner, please check the last page of my note of my booklet, because that's where I put my answer to this question. That's not allowed anymore because that's an unnecessary marking, right? So, sa law school, nagagawa yun dati, puro anos. You try to direct your professor on where to do.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like, for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or, for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish to the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial agreements.
He may be held liable for staffa by misappropriation or conversion. Okay, staffa by misappropriation or conversion. Why can't that not be theft? Why can't that not be carnapping, which is of similar nature of theft? Okay, it is because Mr. A's possession over that car is not only physical or material, it is juridical as well. For the next 7 days from the time he rented the car, okay, he not only has physical possession of that car, he has juridical possession of that car as well. Why did I say that?
The other source of labor principles is the Constitution. Do not enter the gates of USC unless you have mastered the four corners of Section 3, Article 13 of the Constitution of 1987. How important is this provision? Based on this constitutional provision, there were questions given in 1988, 96, 98, 2007, 2008, 2009, 2011, 2012. So if this constitutional provision figured in those barriers, then it means that it is an area that requires mastery. The first question in 1998 was this: what are the salient features of the protection?
It is provided in the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
Ang unang-unang pumaparte sa mana, BIR, kasi mayroon tinatag na estate tax. Okay? Maganda ngayon, isa na lamang ang rate, 6% 6% na lang ng net estate. Okay? Unlike before, the computation of the estate tax was a little complicated, and long before, meron ng estate tax, meron pang inheritance tax na mas magulong po i-compute. Kaya lang, fortunately, ito panahon ni Presidente Duterte, legislature passed a law simplifying the computation of estate taxes. A flat rate of 6% of the net estate. Hindi na graduated.